have you read the Met's guidance on public filming?
I don't need to explain what I have done to you, what I haven't done. I have the powers to do what I'm doing.
Here, we break down encounters between the public and the police, examining the law, officer conduct, and surrounding context so you can understand your rights, their responsibilities, and where the legal boundaries actually lie. Today's episode features the laughing auditor. Filming the MI6 building is ordinary tourist behavior, something that happens daily and typically attracts no attention. Yet, in this instance, that same harmless act triggers an unnecessary and exaggerated police response. Rather than arriving with a clear lawful purpose, the officers appear to operate from a posture of intimidation. Their rapid escalation, moving straight to threats of search, seizure, and forced deletion of footage, suggests a departure from proper procedure. Instead of applying the law fairly and proportionately, their conduct reflects an impulse to control and suppress lawful public recording.
How you doing? Oh, awesome. Thanks for letting me know.
What's your business?
Sorry, do you mind identifying yourself, please?
Right. All my details are there for you to see. That's my shoulder number. I don't have to tell you anything else. Right.
2656 and yourself. Can you identify yourself, please?
Yeah. My number there?
Okay, how can I help you?
Right. What is your purpose for being here now?
Pardon?
What is your purpose for being here now?
I don't answer personal questions.
Okay. Do you realise what building this is?
Yes.
Right, and you're filming?
Yes.
Why? I'm going to ask you why that is.
I don't answer personal questions.
You don't answer personal
No, is that a crime for me to film on public pavement?
Well, considering...
Sorry, it's a yes or no answer. Is it?
Potentially.
Potentially. So what crime do you suspect me of committing?
Okay. It all depends on what you want to use the footage for.
Really?
Right, so let me explain to you. So if this is a reconnaissance for a planned entry later on, or to identify the movements of the personnel working here, to identify when the security are at one particular location and when they are at another location. If this is to figure out ways in which you can access the building, then it's obviously potentially criminal.
The officer approaches with an immediately hostile attitude, treating TLA as though he is already suspected of wrongdoing simply for standing on a public pavement. When he suggests that filming could potentially be a crime, he is not clarifying the law or protecting the public. He is misrepresenting it in an attempt to pressure TLA into leaving. There is no law in the UK that makes filming a building from a public place inherently illegal, and that is a point the officer should be aware of. Recording a landmark from a public sidewalk is generally lawful. By blurring that distinction, the officer undermines proper legal standards and replaces them with convenience-based assertions of authority. Rather than enforcing clear legal rules, he appears to be improvising justifications in real time because there is no solid legal basis to prevent TLA from carrying out a perfectly lawful activity.
You're talking dribble, man.
Pardon?
You're talking dribble, talking nonsense.
Explain why it's nonsense.
How do you know what I'm doing?
No,
you don't
didn't say I know what you're doing.
So
I didn't. Hang on a minute. I didn't say I know.
No.
You said.
So if you suspect me of doing that, what grounds do you have to suspect me of doing that?
Right. So under the Terrorism Act, I have a right to check their phone for the footage, right? Okay. And if I believe it contains any terrorist evidence, I can actually seize that phone. Okay. I can do that.
So what part of the Terrorism Act are you going to use?
Section 43.
Section 43. Yeah. Right, okay. So what are your grounds for using that?
Right.
You need to have grounds, articulable grounds.
My grounds are if I have reason to believe that you are obtaining the footage so that it can be studied later on to figure out the weak points.
Yeah, okay, I get what you're saying.
When the security officers are not alert, what time they're leaving, what time they're starting, so that you can plan an entry at a later time. Right, okay. That constitutes a terrorist intention.
So how does viewing my footage give you that information? Because I've been around filming the building and I've stayed on public...
Invoking Section 43 in response to nothing more than someone using a camera appears disproportionate and suggests the situation has escalated without a solid basis. The implication that TLA is somehow scouting the building for criminal intent is difficult to justify, especially given the context of openly standing on a public pavement in broad daylight. In reality, anyone planning wrongdoing would be unlikely to do so in full public view, filming in an obvious and exposed location. That makes the suspicion being raised appear speculative rather than evidence-based. From that perspective, the officer's approach comes across less as a grounded security assessment and more as an attempt to force a predetermined outcome. There is no clear legal foundation for treating routine photography as a counterterrorism concern in this context, framing it as such risks stretching the purpose of these powers beyond their intended scope. When legislation designed for serious threats is applied in situations like this without clear justification, it raises questions about proportionality and the proper use of authority.
It's public the whole
we
time.
haven't been here to see what you've been doing.
Right, okay.
We've been called saying that you're filming.
Yeah.
So if I looked at the footage, hang on a minute.
It's filming a crime.
If I looked at the footage, I believe that you are watching personnel. You're trying to figure out the weak spots, entry points.
Is this all for a man with a camera? Is that what you're here for as well? That's ridiculous. Totally disproportionate.
So why don't you tell me, if you tell me what you're doing, we can at least make an informed decision.
I'm filming the MI6 building.
And what is the reason?
For my own personal purposes.
Well, you've got to understand, sir, it's a protected site.
So
So
let's
see
just
people filming it.
So am I being detained at this moment in time?
Okay, at this particular point in time, I'm going to ask that I have a look at your footage.
So I'll ask you again, am I being detained?
Yes, you are detained for the purpose of a search, yes.
For the purpose of search of what?
Because I'm going to have a look at your footage.
And what section are you using?
43 of the Firearms Act.
Terrorism Act, you get it right?
Yes.
And what are your grounds for that?
Because I've explained that two times.
But have you read the Met guidance on public filming? No. Have you read the Met guidance on public filming?
Right. Are you obstructing the search?
I'm not obstructing the search, no.
Detaining TLA under Section 43 appears to be a misuse of authority. That provision of the Terrorism Act is intended to apply only where there is reasonable suspicion that someone is involved in terrorism, and ordinary activities like recording in public do not meet that threshold. The situation is further undermined by the officer's own admission that he had not reviewed the Met's internal guidance on public photography. That raises serious concerns about whether he fully understood the legal framework he was attempting to enforce. Rather than applying the law correctly, he seems to have acted on incomplete knowledge and confidence without proper basis. When challenged, the obstruction allegation comes across less as a justified legal step and more as a defensive response to criticism, shifting attention away from the original lack of clarity in his reasoning and conduct.
But what I'm saying is, have you read the Met's guidance on public filming?
I don't need to explain what I have done to you, what I haven't done. I have the powers to do what I'm doing now.
Okay.
I've explained to you why I'm doing it. Right?
You do realise it's a bit unlawful?
No, it's not unlawful. If you believe it's unlawful, you can make a complaint.
Oh, I will do it, 100%.
You have all my details.
Right? I'm not being aggressive, I'm not trying to be hostile, but you're currently trying to infringe on my rights, sir.
No.
So you are 100%. You're misusing...
You asked me the section.
Do you know why Section 44 was repealed? Do you know why Section 44 of the Terrorism Act was repealed?
I'm not here to have the discussion.
Do you know why it was repealed?
I'm not here to have
because of situations like this.
Right.
Because you're abusing your power, sir.
You are entitled to make a complaint.
I will make a complaint, yeah. And there will be a civil matter in relation to that as well.
I've explained to you why you are filming an important building, right? And I've said the grounds are, if I believe you want to study that footage, so that way you can ascertain the weak points, you can ascertain the movements of personnel that work here, so that you can know the best time to enter. That constitutes a terrorist intention.
When the officer states that he does not need to confirm whether he has read the official guidance, it raises concerns about whether his actions are being driven by proper procedure and legal standards. Instead of clearly grounding his decision in established rules, his response suggests reliance on personal judgment rather than consistent application of policy. He asserts the power to detain, but using that authority without clear, evidence-based grounds risks turning a lawful tool into something that appears arbitrary or excessive. The justification being offered leans heavily on speculative, what-if scenarios, including the idea that filming security personnel could indicate terrorist intent. However, under the law, reasonable suspicion must exist before a detention takes place, and it must be based on objective facts rather than assumptions formed after the fact. Detention cannot be used as a way to investigate whether suspicion might exist. It must already be properly established at the point the power is exercised.
Your video.
Oh, okay.
To see how that footage is informing you. If I believe it's
this
just
is crazy
of the area,
this is insane.
If I believe you're watching personnel, you're trying
so
to.
What, you're going to abuse your powers to find out. No, you are 100%.
It gives me the powers to look at it.
Yeah, but you're abusing it. There's no grounds, but because I'm filming. Right. Okay. Because I'm filming in public.
First of all, let's get some details. So
I'm not giving you my details. Under Section 43 of the Terrorism Act, I'm not obliged to give you my details, sir.
Okay.
Okay, you understand that? So you won't find any ID on me.
You don't have any ID?
No.
Okay. All right. Well, I'm detaining you under the Terrorism Act. So I'm going to search you. Take your hands out of your pockets. Let me see your hands. Keep them I can see it. Just hand over your gun.
1 second. I just want to pause this. 1 second, so that you can view it. Yeah, you do.
Pause it. This one.
It's still recording. Yeah. You need a court order to delete any footage. Do you understand that?
No, I'm not deleting.
Okay.
Help me make an informed decision based on the content.
But no,
because the content was quite intrusive. That's why I had to make that decision.
Can I just tell you something, right? You've used Section 43 of the Terrorism Act. Yeah. You need to have reasonable grounds to enforce that. A man with a camera, it's clear on the Met's website, is not grounds to stop someone under Section 43 of the Terrorism Act. No. So you've made yourself liable. So,
like I said, the grounds were the fact that you were filming is set to a protected
that's
site.
not a crime. That's not a crime. People film Buckingham Palace. People what about dash cams going past here?
The officer's attempt to obtain TLA's personal details came across as an escalation at a point where the legal justification for the stop was already being strongly questioned. TLA, however, declined to provide unnecessary information and asserted his understanding of his rights within the situation. When the search ultimately produced no evidence, it reinforced the argument that there may not have been a solid basis for reasonable suspicion at the outset. The reliance on broad or speculative concerns, such as references to protected sites, was also challenged as insufficient on its own without clear supporting facts. This situation is then used as a springboard into a broader discussion about legal awareness and public understanding of police powers in the UK. The idea presented is that people often only fully understand legal thresholds and procedures when they find themselves directly involved in an encounter. The platform being introduced is described as an educational tool focused on explaining UK legal processes, including interactive guides on police powers, decision-based learning scenarios, and explanations of how different actions may affect legal outcomes. It also claims to include informational updates on policing and legislation, as well as tools intended to help users understand procedures such as complaints or information requests. Overall, it is framed as a resource aimed at improving public awareness of legal rights and police procedures, with a focus on education and preparedness rather than reaction after an incident occurs.
But the thing is, in order to ascertain whether it's a crime, it depends on the nature of the See, the crime itself is the terrorism. So
Right.
filming is not a
So you
crime.
need to have reasonable grounds to suspect of a terrorist.
Filming is a precursor to the crime.
No, it's not. Filming is not a crime, sir. Filming.
No, I said precursor.
Right.
It's a precursor to the crime. What I mean by that is, you don't wait till the building's blown up. You intervene at the point of the person preparing for it.
But you need I get what you're saying. Prevention is better than cure and all
Exactly.
that. But you need reasonable grounds, and what you had wasn't reasonable grounds.
It is reasonable. I mean, we obviously we can argue
around circles all day, 100%. I've just got one thing I need. Well, two things I need to say. Your colleague told me about his camera. Part of your policy, you're supposed to tell members of the public first opportunity, and you didn't do that.
We get another call that you hear the same thing's going to happen again. And we're just being a cycle, isn't it?
We'll see what happens.
My advice is please move on.
Yeah, I'll move on. I'm going to stay on public because filming for public,
you're allowed.
and I can point it at the building.
Okay, see,
But I can because you know I'm not here for terrorist purposes.
I don't know that. I've taken the video off you, which would have helped you do that. But once you start looking into,
right, I'm not going to do that. Okay, but I am going to film the building from public from here.
The officer appears to escalate the situation by warning about potential future attendance if further calls are made, despite no evidence being found to support any suspicion related to terrorism. This raises concerns about whether the response is being used appropriately or instead as a deterrent against continued lawful activity, such as public filming. Rather than clearly and calmly explaining the legal position around recording in public spaces, the approach comes across as focused on asserting authority in a way that may discourage further complaints or engagement. If filming is lawful, then using the possibility of repeated police attendance as a warning could be seen as blurring the line between enforcement and intimidation. TLA's response in maintaining his position highlights the importance of understanding rights in public interactions and challenging assertions that are not clearly supported by evidence or law. The core issue remains whether the actions taken were grounded in objective reasonable suspicion at the time, or whether they were influenced by frustration once that suspicion could not be substantiated.
I'm not going to go up there again.
If one of them call us again and because they believe that you're filming intrusively, we'll be back and do the same thing.
But if I'm in public, then that won't matter.
If you're filming intrusively,
What's defined intrusively?
if you're filming into a private ground, because this is public,
Right, but you
that's
can.
private ground.
Okay.
Now
so
it's one thing just doing, I'm taking landscape pictures. But when you start looking
No,
into,
but listen to what I'm
it's
saying. That's what I'm saying, right? If you lived on a street where people were able to drive past and look into your living room, what would you do?
It's called voyeurism.
What would you do if people were able to drive past your house and look in your living room window? What would you do?
That's called voyeurism.
Close the curtains.
Because you are watching me do private.
No, but
private things.
if you can't help it, it's in my
I'm
line of
nice,
sight.
man.
Yeah, whatever.
My advice is to
Listen,
move on, because
there will be a complaint and there will be civil claim against you because
give
what
you
you've
my
done,
detail, that's fine.
what you've done
But
is
if we have
it's
to come at
unlawful,
this time,
sir. You've infringed my rights.
No, I
You
haven't.
have
I've explained
100%.
everything I've done.
No, but it's
I've
illegal what
explained
you've done.
No,
It's
it's not.
unlawful.
It's not.
Yeah, you didn't
When
have
you
legal
make a
grounds.
complaint-
We're going to stand here arguing all day. You need to walk away.
No. So I've said to you, if they have to call us again, we'll come back. We'll do the same thing all over. So it's in your best interest.
Well, every time they do it, it's fine. Because if you keep doing what you're doing, you'll have another claim against you.
The statement from TLA's bio makes it clear that the incident was not something intended to be dismissed or ignored. It indicates an intention to pursue accountability regarding what was viewed as an unjustified terrorism-related stop, alleged disregard for Met guidance, and an improper request for personal details. Despite efforts to find any public record of a complaint outcome or civil claim, there appears to be no available information confirming how the matter was ultimately resolved. As a result, the situation is left without a documented conclusion, Apart from the suggestion that legal escalation was considered, a key moment in the encounter was the officer's assertion regarding what TLA could or could not observe from a public place. This raised questions about the basis of the officer's interpretation of public access rights and whether it aligned with established legal principles about what can be seen from public spaces. The officer's decision to disengage at the end of the interaction is presented as a failure to substantiate the earlier claims made during the stop. From this perspective, the situation did not result in any confirmed wrongdoing on TLA's part or any formal enforcement outcome, leaving the justification for the stop unresolved. Overall, the incident is framed as raising broader concerns about how counterterrorism powers are applied and the importance of ensuring they are supported by clear, lawful reasoning and evidence-based suspicion.